Look, you got to make somebody care to win a motion against a debt collector. Brought to you by yourlegalagot.com, your advantage if you're being sued by debt collectors. Sometimes I get stuff that amazes me, but then I take a step back and it makes a little bit more sense in a way. The way people sometimes file motions or deal with the courts in general is like that. In this case, I'm talking about a motion to dismiss I saw recently filed by a pro se defendant. We had discussed the merits of this motion in detail, and I thought he had a strong argument and a good chance to win. He lives in one state, and the plaintiff brought suit in another. We thought that the court should dismiss the case based on the plaintiff's failure, the debt collector's failure, to state any basis for the court in which the suit had been filed to have jurisdiction over him. He filed his motion in one line on a form given to him by the court to file a motion. That form had three whole blank lines on it. The entire motion that he wrote was, defendant moves to dismiss based on lack of jurisdiction over his person. Yes and no. Yes, that was the motion, but it wasn't even enough to be the title of a motion. Let's briefly take a look at what the motion should have said and then discuss why a defendant, fully aware of the things that should have been in his motion, didn't put them in there. The title of this particular motion should have been Defendant's Motion to Dismiss for Failure to State a Basis for the Court's Jurisdiction. Then the motion itself should have pointed out the operative facts, namely that defendant does not live in the state in which the court is located, and there's nothing in the petition linking him to the state. It's unconstitutional for a state to try to exercise power over someone who does not have certain minimum contacts with it. And finally, either by attached memorandum or an argument, that was part of the motion itself. And as simple a motion as this one was, that would probably be okay. There should have been an argument that the court's asserting jurisdiction without facts proving its power to do so would be unconstitutional. Why does it need to be like that? Let's take them step by step. Caption or title. A motion needs a name. Why? Because different motions are treated in different ways, and the person reading the motion first and deciding how to file it is not the judge, or a lawyer even. It's a clerk who receives somewhere between 10 and 500 of these things per day. Second, because when the judge does finally read the motion, he or she is tremendously busy. She gets the same motions the clerk does and would like nothing better than to ignore them. Wouldn't you? You need to tell the judge you mean business. And you need to make it really easy to see what that business is. Thus you give a title which says what you want and why. That's the way the lawyers always do it. Next comes the body of your motion. You have to tell the court what it is you're saying. If you think the plaintiff had to state a jurisdictional basis for the court's power over you and failed to do so, then you should say it loud and clear. Unmistakably. You go through every step of the argument, making everything crystal clear and not leaving anything to be guessed at or filled in by the judge. You do this, again, because the judge is busy, gets a lot of these things, and would rather they go away. They won't fill them in for you in most cases. You also do it because you want, one, for the judge to take you seriously, and two, you want the other side to take you seriously too. And then comes the argument or reasons. In most motions that are not basic, you will put a sort of abbreviated version of your argument in the motion itself, and then a longer, fuller version of your argument in your memorandum in support. Many, and perhaps most courts, require that every motion be accompanied by a memo in support. We don't like one-line motions on court-supplied papers at Your Legal Legat. Why? Because it screams amateur or doesn't care, or both. Sorry to be blunt, but lawyers never fill in blanks in pre-printed forms, and when you do, it marks you as unprofessional. Not to mention the fact that they don't give you enough space. The amount of space they give you is just ridiculous. You don't have enough space on these forms to do anything. That's why our materials give you templates for your motion or response to motion. That part's easy even without our materials though, because you just have to be willing to put in the work to copy what your court likes and use that. Do what the lawyers do on this. Look up cases and copy them. It isn't that the format is required. The court is happy to process pro se parties all day on one-line motions. But do you have to ask why lawyers would never do it for their clients? It's because if you want to get justice, you usually have to step off the assembly line to get it. That's an individual thing usually. Now, why don't people always understand this? I think it's because the law is not as much like ordinary life as you may think. In ordinary life, you might have a conversation with someone, get interrupted, and then pick up the conversation where you left off. That person is, you could hope, interested in you and what you have to say, and that person has a relationship with you. That person may also not have a million other things to do. You might even be doing it by tweets or Facebook chat, where the conversation is sort of recorded. The law is not like that. You can't tweet the court, even if their stupid forms seem to suggest that you can. In law, you are in a system that often has hundreds of things happening all the time. Your judge will pick up and look at many cases every day, each with a dozen arguments, maybe, that have to be individually weighed and decided. She has 1,000 things going on at once, decisions to make in both civil and criminal cases, and lots of other things. She probably wouldn't recognize you in court, much less out of court. We're talking serious informational overload. These are not bad things. They're just the way they are. Know what you're dealing with. And remember, every decision a judge makes on your case is reviewable by a court of appeals in one way or another. A one-sentence motion on a pre-printed page means that there's basically no way an appeals court would ever reverse a judge for anything. There's nothing to review. Is that what you want? Say no. You're not in Kansas anymore, and you can't expect the person reading what you say to know or care about you. You got to make them care. Our job is to help you do that. We help pro se parties understand and deal with the legal system. Although we don't give legal advice, we do have frequent teleconferences for our members. You can call in real time and discuss what's happening in your case with us and other members. We can help you translate what the other side is saying, figure out what you're doing, and discuss options on how you might respond. That way, you don't have to be confused by all the things going on in your case. We provide manuals that explain in great detail in plain English what's going on in your situation, from what your legal options may be to how to bring motions. We have member-only videos and articles, and we have motions packs, which do a lot of the work of filing or responding to motions for you, among many other resources. If you're in court, worried about going to court, or think you should go to court, but can't afford a lawyer or don't know what your rights are, you should join us. Debt collection is a social justice issue. Take action to protect yourself from the debt collectors and help others do the same. Please like this video, share it with anybody you think could use it, subscribe, and comment, as all these things help other people find our materials. yourlegalegup.com